This is Matt King from the Office of Privacy and Data Protection. And again, thanks for joining us for this presentation on the Keep Washington Working Act. The act includes important protections for Washington's immigrant population, and also includes some of the most significant privacy requirements that have passed through our legislature in recent years. We're fortunate to be joined this morning by two great presenters who have graciously offered their time and expertise. Nick Brown is a partner at Pacifica Law Group who is serving as a Special Assistant Attorney General, and Alejandro Sanchez is a Special Assistant to the Governor. So without further fanfare, I'll go ahead and turn it over to Nick.
Thank you, Matt, and thank you to everyone for joining. As Matt said, I'm a partner at Pacifica Law Group, a law firm here in Seattle, but I was retained over a year ago by the Attorney General's office as a Special Assistant Attorney General, specifically to work on the Keep Washington Working Act and the requirements that are on the AG's office. Prior to coming to Pacifica, I worked for Governor Inslee in Olympia for 4.5 years as his general counsel. So I may have met some of the folks that are on this call in my prior capacity. But thanks again for everyone to join. I do encourage folks as I go along and as Ale goes along, if you have questions, please do make a note of them or drop them in the chat room so we can try to address everyone's questions as they come up. So I will go ahead and start. So the Keep Washington Working Act was passed by the legislature in 2019. And as Matt indicated, it really implemented a number of new and significant changes about how both state and local agencies address the immigrant and non-documented persons in Washington state. So I want to cover these. Most of my presentation is at a fairly high level, but we'll talk about some of the specifics as well. I know that some folks on the call are probably familiar with the act, but there are a number of people who weren't following it when it was passed, and some of the changes that have come since its passage. So like I said, it was passed in 2019, and it was aimed at ensuring that Washington remains a place where the rights and dignity of all residents are maintained and protected in order to keep Washington working. A number of people, when this was passed, were referring to the legislation as a sanctuary state bill because of some of the protections. There are a number of different provisions that affect the privacy and data collection of the immigrant population in Washington, but it is really focused on the legislature's high-end goal of making sure that all of the residents, no matter of their status, no matter of their citizenship, no matter where they were born, feel safe and are protected in Washington state. When the legislature passed the bill, it was done in recognition that Washington has a significant and contributing immigration population. Nearly 1 million Washingtonians are immigrants. That's 1 out of 7 people in the state. They make up approximately 16% of the workforce in Washington. 15% of all business owners were born outside of the country. The legislation was really focused on recognizing and protecting the contribution of the immigrant workforce and making sure that both workers and businesses and governments understand that their rights are to be protected. Prior to the passage of the act in 2019, there were a couple foundational pieces that really, I think, pushed the legislature to formalize some of the protections that we'll talk about in statute. And I'll focus on this first one here. In 2017, Governor Inslee issued this executive order 1701. It was actually the last executive order that I drafted in my capacity as general counsel for Governor Inslee. I know you guys have seen prior executive orders, but it really laid out in the whereas provisions, which you can see there on the left of your screen, a recognition of the importance of diversity and inclusion and different cultures in our state, as well as the contributions of all the residents in terms of their work in Washington. So there are a number of whereas provisions that set out sort of the basis and intent behind this executive order. And then on the second side of the screen there are a number of specific directives to the agencies that report to Governor Inslee as the chief executive of the state. And many of these provisions are echoed, as we'll see, in the act itself. So both executive and small cabinet agencies are really required through this executive order, now over 3 years old, to make sure that they only collect and data that is necessary for the agency's purpose. As many of you know, for a long time, not only in Washington government, but local governments and across the country, agencies got accustomed to requesting a whole host of information that may or may not have been necessary for the purposes that they were interfacing with the public. So this was a reminder and a directive to state agencies under Governor Inslee's control that they should only collect that information that is necessary to perform their duties or is otherwise required by state or federal law. And it made specific prohibitions that you can see around in number 6 here on the right, around requesting information about people's immigration status or their citizenship. So really this laid the foundation for the Keep Washington Working Act a couple years later. As you can see in this executive order, this built on a prior executive order from 2016 that was that we drafted in conjunction with OSE around limiting data collection and making sure that privacy was a focus of all state agencies. This is one of the foundational pieces for the act passed by the legislature. There are really some big bucket provisions that were created in the act that are reflected here on the screen. First, it created a statewide work group housed in the Department of Commerce. It had 11 members from across the state from a number of different professional fields, develop strategies, conduct research, and support efforts to ensure the stability of the immigrant workforce and support immigrant business owners. This is called the Keep Washington Working Act for a reason, and it's because the legislature, much of their focus was around how do we support the economic participation of immigrant workers, immigrant businesses to make sure that they are safe and protected. I think we have all heard over the years how immigrant populations are often a target from federal enforcement of immigration laws, often at the workplace, which has a tremendous effect on the ability of that population to participate in our economy. So much of the act was focused around the economic issues and economic participation. That's what the work group's focus was on. It also clarifies the role of state and federal immigration enforcement responsibilities, and really just a reminder that the federal immigration officials are almost exclusively responsible for immigration enforcement. This is not, as a matter of law, an issue that falls within the authority of state or local law enforcement, but instead to federal officials. So most commonly through Immigration and Customs Enforcement, through Customs and Border Protection, federal officials and not state officials. And the Act makes great pains to clarify that and reinforce that focus in a number of different provisions. It also recognizes a person's immigration status and their presence alone in the United States is not a matter for state or local police. Being undocumented in a state is not in and of itself a crime. There are a number of different situations where someone can be undocumented but have not violated the law. And so the provisions here throughout the Act reinforce these provisions. It also requires state agencies to limit the type of data that they collect, again, building on the executive order from 2017. And as we'll talk about in a little bit more detail, is focused around ensuring peace and safety in public spaces. And specific to the Attorney General's office, a real focus on making sure that the public, whether documented or undocumented, feel safe and are protected in our public schools, in Washington courthouses, in our health facilities, and public shelters. So the big piece that was required in the Act on the Attorney General's office was the development of model policies. So the legislature determined that the Attorney General's office should meet with stakeholders and develop model policies for public schools, public health facilities, courthouses, shelters, and state and local law enforcement. And it required specific stakeholder outreach to stakeholders in each of these sectors, and then the publishing of model policies. So much of earlier this year, pre-COVID, and last year, myself and a colleague from the Attorney General's office spent a lot of time traveling across Washington, having conference calls and meeting with stakeholders to get their input on these various issues, to see what sort of practices they had in place and how we could best develop model policies for them. So the pictures on the bottom here are all the cover pages of the policies that the Attorney General's office published in May of this past year. So we had a year from the passage of the act to develop and publish these model policies. And those are available on the AGO's website and have been distributed to stakeholders in each of these areas. And with one exception, each of the model policies have to be adopted by the local entity, or alternatively, the entity, the local agency, has to tell the Attorney General's office that they're not adopting our model policies and explain why and how the policies that they have are consistent with the act. So, for example, we published a model policy for Washington courthouses, and the provisions in the model policy set forth a number of recommendations and a model policy for how courthouses should interface with federal immigration authorities and with the public, and how they should collect data, how they should respond to requests for data about the immigrant population, a number of different provisions. And courthouses across Washington are now required to either adopt our model policy or publish their own model policy that accomplishes the same goals. One problem, frankly, from my perspective with the act is that it did not establish a particular deadline for local governments to adopt or publish their own model policy. So we've started slowly to see model policies trickle in from a number of different local agencies across the state, principally from law enforcement, which is a big focus of the act. But we're still waiting on other local jurisdictions to publish their own model policies. COVID certainly has slowed things down, of course, for everyone, but hopefully we'll see more come through before the end of the year. Or alternatively, the legislature could, of course, amend the act to set a specific deadline in the future. So I'll talk a little bit about the considerations and best practices for data collection and security that are set forth in Keep Washington Working Act. Just as an overview, a number of different legal considerations they're important. And as the legislation was being developed, and certainly in our stakeholder work, there are a lot of questions about how Keep Washington Working interfaces with the federal law and whether or not this was constitutional. And at the same time this law was being passed, there were a number of cases that were being litigated across the state. Other states, California most principally, but a number of other states had developed similar laws to the Keep Washington Working Act, and many of those are being challenged in federal court. But we do have and had good guidance from those cases about the provisions, how they would affect provisions of the Keep Washington Working Act. So the most significant law comes from 8 USC 1373, which governs communications between government agencies, state agencies, and it still says INS, which INS doesn't exist, but ICE. And that restricts agencies from prohibiting their staff from sharing or receiving information stating what a person's citizenship or immigration status is with federal immigration authorities. And in our mind, and the Keep Washington Working Act does not conflict with federal law. It prohibits state agencies from collecting, using, or disclosing immigration status information for immigration enforcement purposes unless the action is required by law or a necessary condition to federal funding. And we'll talk a little bit about the funding requirements. It also is consistent with the 10th Amendment, the commandeering doctrine, and again, has been upheld in federal court thus far. Importantly, Washington law defines immigration and citizenship status somewhat narrowly, and it's defined as such status that has been established by such individual under the Immigration and Nationality Act. Therefore, speculation about a person's immigration or citizenship status or information does not constitute information regarding their citizenship status. Again, this is really aimed at, within the Act, prohibiting from law enforcement from speculating about an individual's status and then contacting federal officials based on only their speculation. The Act also amended past information sharing laws. So previously, RCW 1070-140 required jail and correctional facilities to inquire affirmatively about someone's status and then to notify federal immigration authorities about their status. So the Act repealed that requirement. So there's no longer a affirmative requirement on officials operating correctional facilities to inquire. There are separate requirements under federal act and treaties, or federal laws and treaties that would require state agencies to disclose immigration status information if they have it. So if for whatever reason officials are otherwise aware or informed about someone's immigration rights, and those folks have rights to contact their consular depending on their country of origin and that sort of thing. But there's no longer a requirement to affirmatively inquire about those issues. So there are a number of different prohibitions within the Act. Most principally was on law enforcement. So law enforcement is no longer allowed to give access to federal immigration authorities to people in their custody unless that person has given their express consent. So it's really limiting the extent to which people operating jail facilities at a local level are cooperating or assisting federal immigration authorities. It prohibits them from collecting or inquiring about such information unless it's directly related to an investigation. So most common is investigations relating to trafficking or that sort of thing. So there's reasons in those sorts of limited cases to inquire about that information. But for the most part, for the types of crimes that local law enforcement are inquiring about, there's not a reason or a basis to inquire about the person's citizenship status. It also prohibits same officials from disclosing that information unless it's otherwise required by law. And it limits the extent to which local law enforcement officials can participate in contracts or agreements. Oftentimes local law enforcement will participate in joint enforcement agreements with federal officials, and the Act fairly curtails the ability for those agencies now to do so. The Act also set forth a number of specific requirements around the ability of state agencies to inquire and collect such information. And again, these really mirrored a number of the provisions that were set forth in the executive order from 2017, just made those now legal provisions and requirements under statute rather than just an executive order. I think everyone knows an executive order is binding on the agencies that directly fall under the governor's responsibility, but it doesn't have a broader impact outside of those agencies for the most part. And an executive order could always be repealed by a prior governor or just by its natural expiration. But now it's the provisions that were established in that EO are now a matter of law. So it prohibits state agency personnel from inquiring about citizenship or immigration status or place of birth, the people accessing public services, it required state agency personnel to review their own policies and their own funding requirements to identify alternative means to get information that they think is necessary for their services. And the act didn't specifically require, but good practice is for agencies to be consistently consulting with their legal counsel to make sure that their programs are aligned with the Act's requirements. There are exceptions to these prohibitions on state agencies. If the information is necessary to properly provide services, if the information is required to determine eligibility in state or federal programs, if it is, again, for law enforcement, directly connected to the law enforcement investigation, or it is otherwise required by law. There are a number of agencies that are bound by federal program requirements or federal statutes to collect such information. So I think all of us are familiar with how state agencies intersect with federal officials and federal programs or federal funding requirements. And so a number of those programs have specific directives to collect citizenship or status information for the purpose of those programs. And the Act does not interfere with those binding requirements that are set forth in federal law. Consistent with what we published in our model policies, we published a number of best practices and policy recommendations around storing information. And most importantly, it's just having an affirmative policy and requirements to make sure that everyone that works in the agency understands what the agency's policies are. What we found in doing our stakeholder outreach to the local agencies is that a number of local entities had good practices, but not very good policies. So a number of agencies were doing things that we hoped they would be doing, but it wasn't set forth in policy. It wasn't clear to everyone that worked with the agency that those, in fact, were the requirements. And importantly, it wasn't clear to the public about what sort of information would be collected or retained by the local agencies. And having express policies is good for the impact it has both for the people that work there and for the public. A real focus of the Act was to make sure that the public feels safe interfacing with the state agencies or local agencies. In my experience, we see this most commonly, of course, with law enforcement or the legal sector. But immigrant populations are much less likely to use government services for fear that their status, if they are undocumented, might be turned over to federal immigration authorities. And so a big focus is making sure that the public understands that government does not request information that is not required by law and does not share information that is not otherwise required by law or court order. And so, much of the work and much of the focus of Keep Washington Working Act is to ensure that people feel safe and open to participate with government, which makes, I think, everyone safer at the end of the day. And a big focus is how agencies respond to information requests. Information requests, as we know, can come from a number of different sources. They can come just via the Public Records Act requests that all state agencies get, or it could come from federal immigration authorities, or it could come from federal agencies simply interfacing with state agencies and requesting information as part of their program requirements. And again, a big focus of the Act is just making sure that we're only collecting information that is required by law or is otherwise required by court order, and importantly, trying to find alternatives to collecting that information if there are available alternatives. I went through that a little bit more quickly than I anticipated. I can stop here and answer questions, Matt or Catherine, or I know Ale is going to present as well, so I don't know what your preference is.
So just to give you a little information, Nick, there have been quite a few people who were not able to join, except for calling in. They were able to get in via their phone, but they haven't been able to see the presentation. I don't really know what the issue is. But so just to let you know that, and if I could get an opportunity to kind of get these people unmuted to see if they have any questions.
Sure.
It's going to take a minute here.
Jed at the Human Rights Commission. I sent in a note to WATEC about that WebEx site being down because I couldn't get in at all either. I had to call in.
Okay.
Thanks, Angela. Have you
Sorry.
gotten any questions?
I haven't gotten any questions related to the presentation.
Okay,
But
and just
people were asking if the presentation slides were going to be shared
I'm happy to
afterwards.
share with you guys.
Okay. Okay, great. Thank you.
Well, if there aren't further questions, I can turn it over to Ale.
Hey, Nick, this is Matt, and I have one question. Obviously, the point of the act is to remove fear and prevent discrimination, but there are some programs that provide benefits specifically to the immigrant population. Is there any guidance you can offer about that?
Yeah, sure. As I indicated, there are a number of state agency programs in particular where collecting or knowing someone's immigration status or their citizenship or place of birth is vitally important to provide specific benefits to those communities and make sure that they're aware of the number of various resources that the state agency can provide. So, the big exception for all the prohibitions that are set forth in the Act with respect to state agencies is the provision in the statute that says unless it's otherwise necessary to accomplish the agency's purposes. That's not a direct quote, but we have interface, and Ale probably can share a little bit more, but certainly there are a number of agencies where we view the work that they're doing as vitally important to continue to collect that information to make sure they can provide services to everyone. And the other piece of that is, even if the state felt it was not appropriate to collect that information, there are a number of specific federal programs that require the state to collect that information. Normally that information is only maintained in the aggregate, and just so there's raw numbers about the extent of people accessing the programs rather than an individualized personal information being shared. But again, if it's necessary for the agency or otherwise required, then the agency should continue to do that.
So Nick, we do have a question in the chat. Are there other states with similar policies?
Yeah, there are a number. I think each one is a little bit different. The most similar were laws that were passed in California at the very end of 2018. It's their House Bill 24 or 54, excuse me. So that's the most similar. There, every state provision is a little bit different. Other states have passed individual components that weren't collectively rolled up into a comprehensive law like we have with the Washington Working Act. Similar to California, California also required their AG's office to publish model policies for local agencies, not for the exact same type of entities that we did here, but California had a fairly comprehensive approach to this as well. And again, there are a number of similar statutes across the country, but just not as comprehensive as Washington and California.
Okay, thank you. And one more. Would this have protected us from giving data to the census if the question had been allowed on the census questions?
That's a good question. Can you hear me?
And yes, we did lose the presentation slide though.
Yeah, I took it down.
Okay.
Sorry. If the question had been required by federal law, then Washington and other states would have been required to include that. But the census doesn't, and I'm not an expert, but the census is a federal program administered by federal officials for the most part. So I don't think it would have put a particular burden on state agencies around that information, but I'm not 100% sure on that.
Oh, and I think as a follow-up to that, Karina says they asked us.
They asked the state to provide information? I see. They asked us for a data share. Yeah. Again, I think that if it had been a requirement in federal law, rather than simply the feds, this is a sort of a generalization, not knowing the specific provisions here, but there are a number of times where the federal government is asking states, Washington, other states, for information around immigration status. So sometimes they're just asking. Sometimes it's a matter of federal law that the state provided, and sometimes it's specifically tied to a funding requirement. So if it was simply an ask for data, then Keep Washington Working would have prohibited state agencies from sharing that information. If it was tied to a funding provision, or if it was otherwise set forth in federal law, then the state would have been obligated. And that's a broad generalization to a number of different areas, but if the census questions were set forth in that same way, then it would apply in that way.
Okay.
All right.
I don't think we have anything. Yep.
I'll turn it over to Ali.
Thank you, Nick. Can you hear me?
Yes, we can.
Okay, great. Perfect. So this, I had a few slides, but nothing nearly as handsome as Nick's slides. So I'm going to avoid having further computer issues, I'm going to hold off on putting those up, but I'm going to talk through them. So thank you, first of all, for having me on. I've met with a lot of the people on this call in certain capacities, but not everyone, so I'm glad to meet the rest of the group. I do work in the governor's office, and this is part of what I do, is review these policies and review the actual requests for data that we get at the state level. And our office does a fair amount of interfacing with the cabinet on the kinds of things that Nick talked about. So I appreciate Nick giving a very thorough overview of the background here. He mentioned a couple things. I just wanted to add a little bit of info for everyone's awareness and context. The Keep Washington Working work group is alive and well. It's been meeting regularly for the past year through COVID. They have lots of platforms they're going to push, not push, but recommend to the legislature. So we're currently working on a report, but that is, as he pointed out, as Nick pointed out, focused on the forward-looking efforts of the state to further illicit immigrant involvement in the workforce. So there are a lot of things happening there in agriculture and licensing, where they're trying to work through the kinds of barriers that either exist now or that are going to come up in the future, and making sure that we professionalize and modernize our workforce going forward. But that is a key component of this act, even though it does fall by the wayside a little bit, because most of the act is focused more on immigration enforcement and the state's role or lack thereof with that effort. I also wanted to point out that some of you may know this, as Nick was working through these model policies, the situation in the state's courthouses got so bad where they would have ICE agents sitting in court waiting for people to have their hearings and then immediately detain them, that the legislature passed the Courts Open to All Act last year. It bolsters the work that Nick was doing. It has some additional restrictions, and it creates some safety around the courthouse grounds themselves, which is important. It's how we get civic participation in a very key piece of our government and our operations. So those are just a couple things to point out. Nick did a great job of giving you a lot of the nuts and bolts. I wanted to just add on one piece, which is, the immigration enforcement side of this is a really important component of the trust or the lack of trust that immigrants have with state, federal, and local governments. There's obviously been a lot of negative rhetoric from the federal administration these past 4 years, but even without the negative rhetoric, there have been so many changes to policies, small and large, that if you weren't paying attention to the back pages of the news, you would miss. But the immigrant communities have lots of networks that share the updates, and ultimately it's just reinforce that culture of fear. A lot of these changes over the past 4 years have been very complex and nuanced in their updates, and they're very difficult for the legal community to resolve. And at the end of the day, it's a broader fear of the unknown for immigrants. And so the immigrant communities, whether documented or undocumented, have heightened concerns about their data for the reasons that Nick laid out. But there's more than just undocumented people being subject to deportation. That's certainly probably first and foremost. And it's important to note that immigrant communities are not a single type of stat. They don't have a single status. I mean, you have families with mixed status households. You have broader families that have people with different statuses, and also you have people who are here lawfully whose visas expire and they don't know about it, and now they're de facto undocumented. You have people who commit minor crimes that do trigger immigration consequences. We now have what's going on with public charge, and I'll just touch on that briefly in a moment, where it's not just single out as a group that is a monolith that we can speak of in one term only. And so that's why this data protection is much more broad of an importance and broad in import, and is a big issue for immigrant communities. And the others are, there's always a general distrust of the government having your data, and that's not just limited to immigrants at all. In fact, we were on a call last year when it was the federal government asking for more ability to access state data, and it was a call amongst state representatives. And the biggest opponents to that were actually the southern states, who were, even though it was under a Republican administration at the federal level, the southern states were pounding the table as much as anyone because of their concerns for their general constituency to not have such oversight by the federal government and overreach potentially. So back to what I was driving at a minute ago, which is, the other issues on the table. Someone has been asking about in the chat a little bit about the census. That's certainly a huge thing that's come up over the past year. You also have the public charge rule, which creates adverse consequences for immigrants who use state and federal benefits. You have DACA recipients right now who are availing themselves of the benefits and the services that they're entitled to, but their status is in flux. And so, we are collecting data on these individuals, and they feel concerned that, with the snap of a finger that, their status is revoked, and all of a sudden all this data has, been collected on them. So it's not just undocumented people, and it's also, just an overall inaccessibility to state services for all of us. I mean, it would be difficult for me to fill out a UI knowledge about it. So you compound that with language barriers and coming from other cultures and countries that don't have the rigid apparatus and framework that we have for our state and federal service delivery. It can be very daunting. So I just wanted to say all that because Nick has laid out the nuts and bolts, but they're just to underscore, what we're facing when Nick and him and I and others from his office were meeting with immigrant rights organizations and immigrant communities, and same with me. It's what we hear all the time. Even though the state has certainly made it clear that we're behind immigrants, there's still trust issues amongst the communities. So just as a follow-up to what Nick was saying, there are a lot of mechanisms for data sharing, as this group is intimately. We at our office do informal requests. We have law enforcement subpoenas that we review. We learn of audits that might look at immigrant data. We have data sharing requests that come up that might implicate immigrant data. We have requests to share resources or to take on new projects with the federal government, and sometimes it's a very sort of neutral looking idea that the federal government might float, but it does have broader implications and will potentially cause immigrants to not want to access or participate in those programs. And that's just on the front end of these things. Like as an example, and this is not a final determination, nor is it a clear, we don't have clear resolution on this, but recently we learned from New York that the vaccine plans would require social security numbers and other things that touch on people's statuses to participate, and that the documents that would be signed might require or might allow for whoever's administering the vaccine to share that data with the Department of Homeland Security. Now we're unpacking that, but that's an example of something that's come up that's newer, that has to be flagged, that has to be taken into consideration. And if immigrant communities get wind of this being an idea, just like they got wind of the census having a citizenship question early on, it's going to be very difficult to reverse the fear that's generated from that and rebuild the trust. So that's something we're constantly watching. The census question earlier was a good one. Nick answered it just as I would. That was the requests that I think DSHS was asking about. Those were permissive requests, so we didn't have to comply with them if they didn't meet our standards. It would be different if we were operating a federal program and they came in and they had the right to audit it. We still want to look at that and make sure that the confines of the audit are appropriate, and we have adequate assurances that the data will be kept for its purposes and not moved around. We see that issue with the taxability of state benefits and the need to provide documents to the IRS as a part of that. So it's not as though we don't have interaction with the federal government with immigrant data. We absolutely do. In some regards, there is one sort of design that is kind of not intentional, but it does work in our favor in one regard, which is that most or all federal programs, except for very few sort of FEMA-related disaster relief or things like that, are effectively banned from being provided to undocumented people. And so to the extent that the state is administering something like that, and they are using a program to check people's statuses to ensure integrity of the program, the expectation is that undocumented people won't be directed to those programs. There's no data on them to collect. Now, of course, that's not a perfect system because, as we pointed out, immigration status is transitory. It's not cemented until you become a citizen. And so it's not perfect, but it is one thing to think about when we think about the requirement to interface with the federal government. That in many regards, though, the times when we're asked to do so are also times where we don't have undocumented immigrants participating. So that's just one thing to think about. But I think overall, Nick has laid out correctly the idea that state agencies, especially those that are named by the Act itself, have requirements to not collect data at the front end without just you have requirements to ensure that the end user of the data is not going to use it for civil immigration enforcement. There's a lot of leeway. Otherwise, the Act does build in the notion that state agencies should be able to conduct their business and not have a broad interference with their ability to do so. But there is always this fallback position where if we have knowledge that that's the end result, civil immigration enforcement, then it cannot be provided, cannot be collected, et cetera. So that's all falling under Section 5 of the Act. Nick has talked quite a bit about Section 6 and Section 4, which will put a lot more of a burden onto the Attorney General's office. The Attorney General is still involved in Section 5, which is the state agency section, which is the section that also mirrors but expands its reach, the Executive Order 1701. What I'll say is that the Attorney General's office also has a role there. They've done an excellent job coordinating internally when providing client advice on the kinds of questions that we're talking about here, like if the Census Bureau is asking for a large amount of data in light of what they had mentioned in private memos and the specter of the citizenship question. So that's why our office and other agencies spent a lot of time reviewing that request, and we get a lot of requests that are not like that, but are also large and have a lot of impact. And yes, of course, we're not getting large requests for data from DHS for Department of Homeland Security for purposes of immigration enforcement, but that's not the end of the inquiry. There's still a general sense that we have to be mindful and safeguard data in any instance. So that's really what my role is part of my role. And so we work with a lot of the agencies on this call on these kinds of issues. And so I'll stop there for questions, and then we'll see if there's any follow-up that we need to do. But I think the people are asking, Karina has asked some good questions there, and it's not just about the census, it's about the census and things like the census, and that's really what we're trying to understand. And in all fairness, it's not a one-size-fits-all answer. Each request or each demand for data or request for collaboration needs consideration by the agencies, and if it rises to the level of our office, by our office too. And so that's why it's just this interactive effort going forward. Actually, I was going to stop there, but I did want to point out one thing, that the federal administration is turning over, and there have been representations from the president-elect about changes in policies that will go into place office. It's important to note that is not the cure where we are. The changes will potentially take place. They have lots of work to do with the federal administration. Some of the changes will take a long time to unpack if they have the will to make those changes. And going back to the public charge piece, public charge was promulgated through formal rulemaking, or maybe it was informal, but it's APA rulemaking. And that the initial rule took over a year to get from the proposed rule to the final rule. Repealing a rule also takes rulemaking. And so public charge is going to remain in force for a while. The detention center in Tacoma is not just going to immediately close its doors. So there are a lot of things that are still going to be going on, and the state will continue to revisit how it decides to work with the federal administration. So that's still on the table. But I don't want to make it seem like everything is going to be fixed, and that immigrants to all of a sudden feel a lot safer. And it's important to note that immigrant communities who have been here from in the earlier under the Obama administration also had serious concerns about their platforms around immigration enforcement as well. So there's hope there, but it's our role at the state level to focus on state business And as Nick clearly pointed out, state business is not the business of immigration enforcement. It's the business of providing services for its residents. So I will stop there and see what we have by way of questions, but yeah.
I'm going to go ahead and just unmute everyone. And that way,
well, we're seeing if there are any questions. I know someone had asked earlier about other states and what they do, and Nick is correct that California has similar laws. Our legal system and our benefits offerings that the state has are the broadest in the country. There are definitely states that have taken particular issues further than us, have been more protective or more generous with their benefits in one regard or another. But if you look at it on the whole, Washington is out front. Their statutes that we've discussed today are more comprehensive. The benefits programs that we have a broader reach. So yes, you will find a lot of states, and I get a lot of calls from states that are trying to come to where we've come to. New York and New Jersey have just passed some, or New York had, and New Jersey is working on driver's license laws to be expanded to undocumented individuals. Well, we've had that here, and here for many years, and so. Yeah, we don't always have the leading, most cutting edge answer, but we are touching on all these issues at the state, and we have good answers for all of them.
Yeah, this is like another thing I would add in is what we're still seeing at a local level is some reluctance from local law enforcement to enforce or adhere to all the provisions of the Keep Washington Working Act. So as I said, there are limitations on how law enforcement interfaces or cooperates with ICE or other federal immigration authorities that they should be doing now, regardless of whether or not they've adopted our model policy. And we're still hearing in a number of different communities concerns about whether, in fact, the local jurisdictions are adhering to that. So there's still a lot of questions, even though this law was now passed a year and a half ago, almost, questions about whether it's being adhered to at the local level.
so a question in the chat box: does this act apply to data or discussions with Canadian ministries?
That's a great question. Not necessarily. I mean, I think I would say not necessarily. That doesn't mean that we don't have data stewardship that we would have, or principles that we would have to apply here. But given that there would be for Canadian ministry, I'm not entirely sure what that refers to. If that's referring to Canadian agencies, if that's how they're termed and can. Yeah, well,
that's Will Saunders.
Is that there?
Basically, if there are questions by British Columbia about the status of whether somebody's an American citizen when they're living in Canada or working or visiting Canada, they might be receiving benefits there from the government of Canada. They are a federal government. They have the same situation we do, but the seems like the concerns are very different.
Well, that's an interesting question, and in some regards, even if it's not tied to immigration enforcement by U.S. officials, it does beg the question why they would ask the state and not USCIS that. So I don't have an answer for you right off the top of my head. I mean, I think we probably would have some authority to do that, but the question would be, would we want to? What is the end result there? Certainly, we want to be cooperative with foreign governments. We have had questions from British Columbia before that we've been able to. So I don't have an answer for you right now, Will, but that would be something to.
Yeah, I would just echo Ale. I mean, obviously the principal concern of the act is for protecting the information from U.S. federal immigration enforcement authorities. So not specifically aimed at limiting contact with other foreign governments, but I would be curious too why they would be coming to the state rather than a federal official to discern someone's citizenship. I could see maybe in some of the state programs if there was a question about is this person a resident of Washington, do they worked previously in the state, that kind of thing, but pure status information, I'm not sure who or why they would direct the question this way.
But good question nonetheless. That's an interesting one. I've not heard that one come across before. Angela or Katie, I'm not seeing any other questions. I do want to thank everyone. Obviously, we have these conversations with agencies a lot. Thinking about this again collectively. Appreciate it.
Yes, this is Katie. Thanks so much to both you, Ali, and Nick for joining us and sharing your knowledge about the Keep Washington Working Act. Some key takeaways, I think, especially for the state agencies, are making sure you have your policies in place. I think Nick mentioned a lot of agencies have the practices, but might not have all the policies and procedures documented. So think about that and to de-identify aggregate info where possible, and then be thoughtful and pay close attention to data requests and data sharing for immigration status data. So I think those are all important aspects that state agencies need to think about, and then stay in touch with Alejandra's office if you're getting those requests, especially, and you're not quite sure how to handle it. I know when I was at DSHS, we were in close contact with you about several requests. So thanks everybody for joining us today. Sorry about some of the early technical difficulties, but the slides will be available and the recording as well. So thanks all for joining us for November's webinar, and have a great fall. Bye.
Thanks, everyone.